Loud little ducky and her ducklings always seeking justice and truth. This ducky won't be silenced by the haters, seeking out the facts while providing the receipts. She is loud with her opinions in this cruel world of villains. This ducky will talk, give her sass, while still keeping her class. So join in the pond with the ducklings from all over the place.
Oh, God. How about y'all? How about now? Everybody, I think I have fixed all the buttons. Okay. All right. So, as I was saying, hey, y'all, we are going to go over why David Gingras just cannot let Laura Owens get all the attention. I guess he was missing us. And so he has decided to enter the remaining of her cases. So, David Gingras is Laura's bestie, and they have to be hand in hand and side by side in every court case that there is. And he has been representing Laura since March of 2024. And out of five cases that have happened since March of 2024, which is insane because I'm counting Owens v. Eckerd. Then we went to Maricini. Then we have the criminal case, but he did not represent her in that one. Then we had bankruptcy. And the fifth one is this injunction against harassment. So 5 cases since March of 2024. And he has been in 4 of the 5 cases. Now, I don't know if he is somewhat helping the public defender or at least Laura in giving her advice behind the scenes to also deal with her public defender. So and even though he wasn't necessarily her lawyer on all these different cases, he has interjected himself. He considers Laura like a really, really good friend, and he feels bad for her and all this other stuff. Okay. The thing is do not be a yes man or a yes queen to your besties, your friends, because they need to hear the truth. A real friend will tell you the truth. Not just yes, queen, yes, you did that. I have your back. No, they will call you out for they will call you out on things that you're doing. And maybe he is doing that behind the scenes, but to the world, he acts like she's just misunderstood. And we know that that is not the case. Like, and he will not take accountability for her or himself. About his bar license, I don't know. I don't know if they're going to be able to bring the disciplinary stuff that they were going to bring. I have a feeling that at least with the DUI thing, that because he got disciplined the last time he had a DUI and had suspension, that he will at least get a suspension of the same or more, at least for that. Now, disbarment, I don't know. It depends on if they can bring anything out of all the other bar complaints that they've got. So, and we know that Gingras writes motions like he writes blog posts. I understand why Gingras wants to do oral arguments over just putting everything in writing and emotions, because for some reason, when he's speaking, he can filter a little bit better. When he's writing, he's that Kermit the Frog meme, just angrily typing away. So we're going to get into that, but make sure you like this video. You comment if you are on replay. You can share it and subscribe. And I know in the last video I talked very slow, but I was mincing words on my last video. Hopefully this one goes a little bit quicker. Replay crew, you can always speed me up. Or if you know I'm slow, start a little late and catch up on a faster speed. Because I get it, because I listen to people at a higher speed too, and I don't talk as fast as I like people to talk. But let's bring up, and then I will also have each document timestamped for replay crew when we are finished. So share screen. So let's start with him wanting to be involved now in the bankruptcy case. We heard a little bit, if you have not seen it on Schnitzel's. We might watch it later on here. That hearing for the bankruptcy where the U.S. trustee's attorney, Jennifer Guillermo, was asking Laura a bunch of questions, and she is like, well, I don't want to answer any more questions because I know I answered everything wrong. And you cannot tell me that she did all this without talking to Gingras first. Like, I feel like Gingras helped her when she first filed all this. And then she threw Gingras under the bus. And then she's now going to have him help her with this other part. And he was like, no, I'm just here for the, was he an arbiter? I don't know. He's wanting to deal with the credit stuff with the Owens v. Eckerd case, that it's attached to the bankruptcy case, and that is what he is supposed to be dealing with. And so he's trying to enter this. So here we have motion for leave to enter limited scope appearance, which apparently is not actually allowed in bankruptcy cases. The more we know. So pursuant to the federal rules bankruptcy procedure 9029C and Arizona Supreme Court Rule 42 ER 1.2D, undersigned counsel David Gingras respectfully moves for an order allowing him to enter a limited scope appearance in this matter. See footnote 1 on behalf of debitor Laura Owens, Miss Owens. Footnote 1 says undersigned counsel currently represents Miss Owens in an associated adversary proceeding, Eckerd v. Owens. I don't know how you can be a part of an adversary hearing and be a part of her bankruptcy, because if I was Clayton Eckerd, I would also be opposing this motion on grounds that the two of them are possibly going to try to get certain things done so it goes their way in the Owens v. Eckerd case. And the two of them shouldn't be able to be in cahoots on the bankruptcy case, which has to do with this debt. As this court is aware, Local Rule 9010-1C1 takes an all or nothing approach to appearance of counsel, i.e., when a lawyer enters an appearance in a bankruptcy matter, the lawyer is ordinarily responsible for all aspects of the case until counsel withdraws or the case is closed. General appearance: an attorney who files debitor's bankruptcy petition and who files a notice of appearance on debitor's behalf must represent the debitor in all matters other than adversary proceedings until the case is closed or the court enters an order approving withdrawal or substitution of counsel. Arizona courts historically applied the same standard. When a lawyer appeared, the lawyer was responsible for the whole case until the matter concluded or the court permitted withdrawal. This was the default rule for many years. Recently, courts have begun to realize this all or nothing approach was too harsh because it could have deprived low-income litigants of the ability to obtain counsel who may be willing to appear, but only for limited purposes. The Arizona Supreme Court modified the rules of professional conduct to expressly permit lawyers to engage in a limited scope representation. See Supreme Court Rule 42 ER 1.2D, stating a lawyer may limit the scope of representation if the limitation is reasonable under the circumstance and client gives informed consent. Based on this change, the Arizona Rules of Civil Procedure were amended to expressly authorize limited scope representation in state matters without leave of court. Well, the thing is this isn't a state court proceeding. This is a federal proceeding. So just because they allow it in civil procedures doesn't mean that they allow it in federal rules. Okay. Although Arizona state courts have embraced the benefits of limited scope representations, federal courts have not yet adopted local rules which address this beneficial practice. Despite this, Arizona federal courts routinely agree lawyers may properly appear on a limited scope even without seeking prior leave to do so. The federal rules of civil procedure do not expressly authorize or prohibit an attorney's limited scope appearance in a federal action. While the local rules of civil procedure in some districts expressly authorize limited scope appearances, the local rules of civil procedure in the District of Arizona are silent as to such appearances. Rule 83B provides that in the absence of controlling law, a judge may regulate practice in any manner consistent with federal law rules adopted under 28 U.S.C. 2072 and 2075 and the district's local rules. In other cases, judges in the District of Arizona have allowed attorneys to appear in prisoner civil rights cases for a limited scope of participating in the court's inmate medication program. Therefore, a limited scope appearance is not inconsistent with federal law or the federal and local rules of civil procedure. Well, I don't think that an inmate's medication program is the same as a bankruptcy thing. I'm just saying. And then he has some Kate cited. Here, just as Federal Rules of Civil Procedure 83 permits district courts to adopt local rules, provided they are not inconsistent with federal laws. Bankruptcy Rule 9029A1 grants that some authority to the court, such as this court, may permit a lawyer to appear on a limited scope basis if a good cause exists. I don't think good cost exists. Here, good cause exists to allow undersigned counsel to enter a limited scope appearance in this matter. First, the undersigned is representing Miss Owens entirely pro bono. Yeah, we make sure we put that on there because the bankruptcy is going to be like, oh, what is she paying you? Miss Owens is currently seeking a Chapter 7 discharge from this court, and she claims substantially no non-exempt assets and no meaningful income aside from support she is receiving from her parents. Miss Owens currently lives at home with her parents. Miss Owens is unable to pay for representation of counsel in this matter. As a sole practitioner who is familiar with the history of events which preceded this action, undersigned counsel is willing to provide some legal services to Miss Owens on a pro bono basis, but not without pre-established limits. The thing is, you don't, well, you know certain things, but I don't know if you know all the financial ongoings from 2023 until present day with Laura and her parents. You might, but and Laura is already blaming you for stuff. So once again, you're willing to put all your eggs in one basket. And why? Why is she the one that's worth throwing everything away? I'm sure there has been plenty of nice people in your life and plenty of friends that you've had in your life. But this girl, like, how does this not just have red flags? Why are you so blinded by her? Why are you so attached to her and this family? It's bizarre. Because I get people have like family attorneys and stuff like that, but not like this. Most of the time, even rich families that, yeah, they may have the same family attorney for all their affairs and stuff, but they're not doing it pro bono. But you are willing to take zero money for it, just a friendship, and throw your career away on this one person. Most sane, keyword, lawyers would not do this. So what makes her so special? Are you going to be the guy that makes her feel special like she's been wanting for her whole life? Is she the one she was looking for? So he goes on to say, for that reason, undersigned counsel proposes to appear for Ms. Owens in this matter with her informed consent under the following limitations. If leave is granted, counsel will appear for Ms. Owens in this matter and will handle all aspects of the case for a period of not more than 60 days from the date the court grants leave. This period should be sufficient to complete any discovery the trustee seeks, as indicated in the trustee's recently filed for, examinations. If this matter is not resolved before the expiration date of the 60-day period, counsel may agree to continue representing her for additional limited periods as necessary. Well, if the judge says you will continue representing her, you're going to continue representing her. You don't get to just dip out because you want to dip out. And I think you would stay the entire course. Because you see she's drowning and you don't like it. And she's probably freaked out at you and had a meltdown. If the amount of work required by additional discovery requests from the trustee or any creditors becomes excessive, what is excessive to you? Because you don't have anything else to do. Undersigned counsel may terminate his representation of Ms. Owens by filing a notice of termination of limited scope representation. Upon such filing, counsel will be deemed to no longer represent Ms. Owens in this matter. For the court's information, undersigned counsel previously met and conferred with trustees counsel Jennifer Guillermo regarding the issue. Ms. Guillermo indicated she would not consent to undersigned counsel appearing on limited scope without leave of court. For that reason, leave is requested for the reasons stated above. February 12th, 2026. And certified all counsels of record have been served, and that there was an email copied and forwarded to Laura Owens. So there's that one. That's him saying, hey, I will represent her on this case. And then we have that's a different case. Okay. So then we also have, let's bring this up. I gotta go back to the public. Okay, leave for appearance. And then he did a proposed order granting that he wants the judge to just sign. Which order granting to leave to appear, and I hereby granting for not more than 60 days, may agree to continue representing, or, the termination. And wants the Honorable Judge Brenda Martin to sign. If this is granted, I don't think it'll be based off of his proposed order. That is my guess. Then we have the motion objecting to Gingras coming on this bankruptcy. So we will share that now. All right. So we have bankruptcy. Owens is the debtor versus the United States. So the United States trustee's objection to motion for leave to enter limited scope appearance. The United States trustee, UST, by and through undersigned counsel, files this objection to motion for leave to enter limited scope appearance filed by Gingras and respectfully submits the following. Debitor Laura Owens filed her voluntary Chapter 7 bankruptcy petition in this case on December 8th, 2025. Debitor filed her petition pro se, and no attorney has entered an appearance on her behalf up until now. On February 9th, 2026, debitor appeared and testified at a continued meeting of creditors pursuant to Bankruptcy Code 11 USC, Code Section 341A, also known as the 341 meeting. The UST briefly examined debitor under oath at the 341 meeting. During the examination, it became clear to the U.S. trustee that a more extensive examination pursuant to the Federal Rules of Bankruptcy Procedure, Rule 2004, would be necessary. Accordingly, after the 341 meeting concluded, the U.S. trustee filed a motion to obtain documents, examine the debtor pursuant to Rule 2004 motion, and the court granted the U.S. trustee's Rule 2004 motion on February 12, 2026. On the same date, Gingras filed the instant motion to leave, entered limited scope appearance, motion to appear. The U.S. trustee now objects to the motion for two essential reasons. One, the local rules strictly prohibited limited scope appearances that Gingras requests, which they do, and Gingras even admitted such. So he knows that's one of the things. And two, Gingras is disqualified from representing the debitor based on a conflict of interest, which we have already seen in the Maricini case. What David sees as conflicts of interest and what the world sees as conflicts of interest and what courts see as conflict of interest are two totally different things. Because David is like, no, there's no conflict of interest. Yes, there is. Because it has been shown that you will do anything for this girl. And it's not to be trusted. You are not to be trusted. And to me, you've proved that over and over. You may say, I do everything by the book, and I hate when people break the law and all of this. But you're not a trustworthy guy. You like to bend, skirt the rules, and go a little overboard. You like to go personal vendetta and personal revenge. We all remember the clip of Gingras telling Laura, I hope you never pay Clayton, which is telling his client to disobey court rules and court orders. Just one second. Sorry, my son had a question. So, Gingras is like, don't pay Clayton. So, do we not think that he's going to do everything in his power as her attorney in the bankruptcy case and as an attorney in the Owens v. Eckerd case to make sure that she never has to pay Clayton? Yeah. Let's see. The UST has no objection to debtor's retention of counsel. It only objects to the limited scope representation that Gingras proposes. So she goes over her first reason. There is no legal basis to disregard Local Rule 9010-1C1. And it states as follows. Let me make sure I'm back. Okay. Hopefully everybody can hear me. All right. An attorney who files a debtor's bankruptcy petition or who files a notice of appearance on debtor's behalf must represent the debtor in all matters other than an adversary proceedings until the case is closed or the court enters an order approving withdrawal or substitution of counsel. Which, yeah, whether you want to be on for 60 days or not is not going to be up to you. It's going to be up to the judge. The local rule, the 2018 notes to this local rule state that the court will enforce this obligation regardless of any limitation contained in any retention agreement between the attorney and the debtor. So it doesn't matter if the debtor and this attorney agree to those terms, the court will enforce what the rule has always been. So just like you can sign a conflict of interest like waiver type thing and maybe some civil proceedings and criminal things, not so much here. Despite this firmly established rule, Gingras asked his court to allow him to provide some legal services to debtor on a pro bono basis, but not without any pre-established limits. Yeah, Gingras wants to change law. He wants his name to mean something other than douche canoe, which it doesn't and it won't. He seeks permission to represent the debtor for 60 days with the option to continue that representation in his sole discretion. Yeah, Gingras, you don't get the discretion in this. Significantly, Gingras will not unconditionally commit to representing the debtor for full 60 days. Rather, Gingras states if the amount of work required by additional discovery requests from the trustee or any creditors becomes excessive, undersigned counsel may terminate his representation. Like, oh, this is too much. I'm not a bankruptcy attorney. To me, you know or should know what you're getting into before you agree to do this. So you can't say, oh, no, I didn't know it was going to be this much work. I'm done. This is not a college course that you can just drop out of. The local rule was specifically designed to prevent precisely the type of limited scope representation that Gingras is proposing. The reason underlying such rule was best explained by the court in Sear. Lawyers cannot indiscriminately dismiss clients at their whim or even if their clients don't pay on time. Lawyers are professionals that owe fiduciary duties to their individual clients and must continue to represent them even if initially rosy predictions turn sour. And then they've got that in the handbook, the ABA handbook, and all that. Moreover, allowing Gingras to enter a limited scope appearance will needlessly complicate the process of obtaining stipulations, exchanging documents, and communicating about various aspects of the debtor's case. For example, it appears that Gingras's proposed limit scope appearance would not cover issues pertaining to adversary proceedings. The UST's investigation of debtors is for the express purpose of a potential adversary proceeding under Code Section 727, as stated in the UST's Rule 2004 motion. Would Gingras be responsible for stipulations pertaining to adversary proceeding deadlines? If not, would counsel for UST be required to communicate directly with the debtor with respect to some, but not all, issues in this case? The confusion as to what issues Gingras will be handling and for how long he will be appearing is too burdensome to justify the request for deviation from the local rule. Gingras offers no compelling factual or legal basis to woefully disregard the firmly established local rule prohibiting limited scope appearances. Therefore, the court should reject Gingras's request and hold that Gingras must enter a notice of appearance subject to the local rule or not appear at all. So she's saying, no, you're either getting in on this case or you're not. You don't get to just be here for a little bit to help her get with the discovery, because it's just so overwhelming for her and it's causing so much stress and mental anguish to her because she got in over her head because people told her to go file for bankruptcy and this will probably fix your problems, when she just should have done the thing in the Owens v. Eckerd case and not done this. But she's trying to get rid of this. And I don't know if anybody warned her about how much they go into. They want it all. And that's a federal court, not just state court. And you can still be charged with more crimes if you're caught doing things. Something that, and the thing is why does Gingras just want to come in on a limited basis? Because we know his ass is in the background helping her with this shit in every lawsuit. She's calling him up with every legal thing she has. You cannot convince me otherwise. So he's going to help her in the background, whether he's actually officially on the case or not on the case. He's going to be doing all this shit anyways. So why? Sure, let's just do it all on the record so that there's a big paper trail of it all. Let's do that. And so Laura doesn't have to speak anymore. It's going to be her attorney. But Laura's still going to get deposed. And we know how much Laura loves having to talk to attorneys because she likes to miss depositions. She likes to miss court appearances when she's going to be questioned. She doesn't like being questioned. And at a deposition, she will be questioned. Now they're moving on to the second issue, saying that Gingras has a conflict of interest. And of course, Gingras does not agree with this, which we'll get to later. Debitor's largest creditor in this case is Clayton Eckerd. The debt owed to Eckerd arised out of a paternity suit filed by debitor against Eckerd in a state court in Maricopa County, Arizona, the paternity suit. During the course of the paternity suit, debitor testified under oath and filed a sworn affidavit regarding her financial condition and income. At the meeting of creditors in this case, debitor was questioned about a particular affidavit filed in the paternity suit in which debitor attested to owning a financial account with over $450,000 of funds. In response, debtor testified that Gingras could explain the circumstances of that affidavit and offered to allow Gingras to testify at the meeting of creditors. Yeah, she was like, Gingras, you can take this one. Ma'am, we're not tag teaming this. Footnote 1, the UST is in the process of obtaining the transcript of the 341 meeting. Schnitzel Ninja YouTube video has a transcript. I know it's not like an official court transcript. It's cheaper, but I'm just saying. Schnitzel Ninja has a type of transcript for that meeting. In light of the foregoing, Gingras is a potential witness who, according to debtor's own sworn testimony, has personal knowledge of highly relevant information concerning debtor's sworn statements regarding debtor's assets and income. Unquestionably, such information is material to this bankruptcy case and directly bears upon two crucial issues. One, whether the debtor in fact had assets and income that have not been disclosed in this case. And two, whether the debtor made a false oath in this case or alternatively perjured herself in the paternity suit. Well, we know she's perjured herself in the paternity suit because, well, she'd be charged with perjuring herself in that suit. Rule 3.7 of the Arizona Rules of Professional Conduct, which applies to attorneys appearing in this court pursuant to Local Rule 9010-1A, prohibits a lawyer from acting as an advocate for a client in a case in which a lawyer is likely to be a necessary witness. See footnote 2. The lawyer may act as an advocate despite being a potential witness only if, 1, the testimony relates to an uncontested issue, which, no, this issue is a contested issue right now, so he can't do it there. 2, the testimony relates to the nature and value of legal services rendered in this case. Nope. 3, disqualification of the lawyer would work substantial hardship on the client. And then she said, see the rules of professional procedure, Rule 3.7. In light of Gingras' knowledge of debtor's sworn statements pertaining to her income and assets in connection with the paternity suit, Gingras is a petitional witness and therefore disqualified from representing the debtor in this bankruptcy case. She also said, in her testimony that he's the one that wrote these stupid affidavits. And he's the one who put her e-signature on it with her consent because she wouldn't dare accuse him of forging it and doing it without her consent. But she's like, my attorney put my name on that. I didn't actually read through it carefully, or I must have not read through it carefully. You knew exactly what it was saying and what you wanted it to say. It's just biting you in the ass now. Because you say what works for you in the moment and not the truth. Wherefore, the U.S. Attorney requests that the court sustain this objection and deny motion to appear respectfully submitted by Eileen Lashinsky and Jennifer Giamo, certified on February 17th, and it was served on Owens and Gingras. All right. So let's take that down. And then let's back up here. All right. Now we need to get to Gingras' lovely response. This is Gingras' response to that reply in support of motion for leave to enter limited scope. So he is replying to Jennifer Guillermo now. And he's a guns a-blazing. And his hyperbolic state that he always does. So let's share screen. All right, let me see if I can embiggen this. Might be hard to read. Check something. Okay. All right. Here we go. So, Gingras says, let's recap. Undersigned counsel David Gingras is an attorney admitted to practice law in California and Arizona. Counsel is admitted to practice before this court and has been practicing law for more than 25 years. Okay, great. Undersigned counsel would like to offer pro bono services to debtor Laura Owens, with the only restriction being as to duration of the representation. Yeah, well, you should just go all or nothing. Why can't you go all or nothing on this? What is your reasons for that? For the reasons appear purely performative and pretextual, counsel for the trustee objects to this. As explained below, there is not a scintilla of merit to the trustee's objection. Indeed, the objection is both premature and ultimately it is based on pure hypothetical issues founded on literally nothing but speculation. Trustees counsel also misstates both the law and the facts. You're known to misstate facts and law. You're known to not do things based on reality, too. Because the objection is premature, speculative, and substantially groundless, this court can and should reject it without prejudice to the issue being revisited later when and if necessary. Well, the thing is she's allowed to object on the least grounds, the first grounds. She's allowed to say, no, you either come in for everything or you come in for nothing. So I don't think that her thing should just be rejected. And with you, we don't like to wait around. We don't like to wait around and find out because you like to fuck around. And because people have she probably knows how you are or has figured it out that she's trying to cover her bases, even if it is premature. And I know you can't do things premature. Omar did things premature as well, but it's because he does shit like this. He has to insert himself into everything with Laura. When Laura needs to just learn to fall on her face and maybe she'll quit doing it at one point. She needs to deal with the consequences of her actions, but people want to keep coming in and saving her from dealing with it. Introduction. Once upon a time, lawyers were encouraged to provide free or low cost services to the needy. This was not seen as a burden, but as an honorable duty owed to the courts by all members of the legal professions. Yeah. And there are still a lot of people that should do things pro bono. This girl is not the one to be doing it with, especially, oh, her parents are in this much. Who gives a shit? I'm sure every single one of your clients, maybe not all of them, or your opposing side needed stuff for the needy. And you don't care about taking away money from Eckerd. He needs that money, but you didn't care about wasting his time and all his money. So much so that you don't even want to reimburse him for it. But Laura needs all her money in her bank account that she can get. She needs this fresh start. You probably think Amber Heard is innocent. You probably think Johnny Depp did things because you're that stupid. Okay. Courts have long recognized that attorneys, because of their profession, owe some duty to the court and to the public to serve without compensation when called on. Yeah, but your number is called a lot for them. And then he cites cases about what a great person he is for, giving his services to the needy, possibly soon to be homeless. Who knows? While few lawyers donate significant amounts of time, the practice still strongly encourages it. The Arizona Rules of Professional Conduct expressly say so. A lawyer should voluntarily render public interest legal service. So this is public interest, right? You agree? This is public interest. Laura Owens is public interest. The court shares the view that pro bono services are a time-honored duty of the legal profession, which benefits not only the litigants, but the court itself. The United States Bankruptcy Court for the District of Arizona recognizes the exceptional commitment and efforts of bankruptcy attorneys and their staff in our districts who assist self-represented parties. The District of Arizona still has one of the highest self-represented filing rates in the nation because you seem to have an abundance of crazy bitches out in Arizona, specifically in and around Maricopa County. Crazy women that have been through that area. Pro bono volunteers help those debtors and creditors navigate through the complicated bankruptcy system. These attorneys greatly benefit the court and all its participants. United States Bankruptcy Court, pro bono honor roll, emphasis added, last accessed on this date. Despite this court's and Arizona Supreme Court's strong endorsement of pro bono services, the United States trustee asked this court to reject such an arrangement here. And why object? Counsel argues with virtually no explanation that the entire weight of the United States Department of Justice is unable to bear the unidentified needless complication caused by allowing an indigent debtor to receive some assistance from a sole practitioner. Give me a fucking break. Oh my God. I am such a good attorney. I am helping the needy here. And the bankruptcy trustee just she just can't deal with an angel like me coming in to help the needy with all that they have behind them. Um, Henrietta, this is it is on Twitter. IT Goatee um got it today, and so that's where it is at. And so I just don't understand why he's not committing all the way. Like, if he gets thrown off, great. Um, but if he if he doesn't get thrown off and this is allowed, I don't understand why he can't just commit because he's going to he's committing behind the scenes. Why not commit on paper and in hearings? This argument is not only meritless, it presented in bad faith. This court should therefore grant leave for undersigned counsel to appear on a limited scope basis in the manner requested in the initial motion. Jesus Christ. Give it to me now. Discussion. A, this court's rules do not prohibit limited scope representation. In his original motion, undersigned counsel explained local rule takes an all or nothing approach to appearance of counsel when a lawyer enters an appearance in a bankruptcy matter. The lawyer is ordinarily responsible for all aspects until counsel withdraws or the case is closed. Despite this, the motion further explained federal Arizona courts routinely allow limited scope appearances. Yes, in other matters, but not bankruptcy. And then in the face of this authority permitting limited scope appearances in federal court, the trustee argues the local rules strictly prohibit limited scope appearance that Gingras requests. Notably, a sole authorized cited in support of this position is language of local rule 9010(1)(c)(1) itself, which of course is entirely silent as to whether limited scope appearances are allowed or prohibited. Putting aside the fact that counsel for the trustee misrepresents the local rule, counsel also ignores this fact. The local rule of the Arizona District Court contained language substantially identical to the bankruptcy court rule 9010(1)(c)(1). Just compare both rules. I don't think the federal court gives a fuck what the district court rule is. So, attorney of record duties of counsel, except as provided below. No attorney shall appear in any action or file anything in any action without first appearing as counsel of record. An attorney of record shall be deemed responsible as attorney of record in all matters, before and after judgment, until the time for appeal expires or until there has been a formal withdrawal from or substitution in this case. The thing is they're not going to just allow you to withdraw just to withdraw. In civil cases you can, because you're paying for that stuff, or even if it was pro bono, they're not going to just say, "Okay, thanks for helping us out here." And so, or there's substitution. So I don't think that your rules in civil matters, in district courts and superior courts and in state courts, are going to fly in federal bankruptcy courts. That is just my opinion. I am not a lawyer, so I don't know, but I don't know that that's going to fly. He's citing to a bunch of things, but he also admits that bankruptcy court does not usually allow this or hasn't allowed this. It is an all or nothing approach. Just because it happens in different cases and types of courts Doesn't mean that it happens in this. Arizona Bankruptcy Court local rule: an attorney who files a debtor's bankruptcy petition or who files a notice of appearance on debtor's behalf must represent the debtor in all matters other than the adversary proceedings until this case is closed or the court enters an order approving withdrawal or substitution of counsel. So let's go back. It says all matters there. So those rules are identical. Thus, in district court proceeding, any lawyer who appears in any case shall be deemed responsible as attorney of record in all matters. In contrast, the bankruptcy court version of the rule states a lawyer who appears for a debtor must represent the debtor in all matters other than adversary proceedings. But you're also representing her in an adversary proceeding. So I don't know if you can do adversary and the bankruptcy because I just don't know if you're going to be able to do that. Substantively, both rules are functionally identical. If anything, the inclusion of the words other than adversary proceeding makes it clear a lawyer who appears for a debtor in a bankruptcy court accepts less responsibility than a lawyer who appears in district court. Yeah, but you're also dealing with her in the adversary proceeding. Despite this, and as was already explained in the original motion, judges in the Arizona district courts with the arguable more restrictive local rule have expressly agreed a limited scope appearance is not inconsistent with federal law or the federal local rules of civil procedure. Cites a case, emphasis added, because bankruptcy court local rules 9010 1C1 is substantially identical to district court local rules LR Civil 83.3A, this court should reach the same conclusion. And what contrary authority does the trustee offer in response? A single out of jurisdiction case. Okay. If counsel for the trustee had actually read Sear, which is admittedly a burdensome 92-page opinion, which undersigned counsel has now read, well, I'm glad you got your reading in, Gingras. She would have known Sear not only does not support the trustee's argument, it supports exactly the opposite premise. Sear did not involve an attorney who requested leave to appear on a limited scope basis. Rather, Seal involved a lawyer named DeLuca who charged a debtor, Mr. Sear, a flat rate for filing a Chapter 7 petition. Unfortunately, the lawyer DeLuca failed to adequately investigate the debtor's affairs. I'm afraid you're not going to be investigating your debtor's affairs. You're just going to take it. You're going to just take what she says as gospel. As a result, DeLuca did not realize the primary debt owed by Mr. Sear was a judgment ordering Sear to pay sanctions in the amount of a certain amount of money for committing fraud on the court. In a prior litigation matter involving a creditor called St. Rose Dominican Health Foundation. Noting in the underlying case, the trial court found Sear submitted evidence in the form of emails that he embellished to boost his claims. Although DeLuca filed the Chapter 7 petition as agreed with his clients, he refused to represent the client in an adversary proceeding filed by St. Rose, claiming this was not a part of his representation agreement with Mr. Sear. The bankruptcy court subsequently ordered Mr. DeLuca to show cause why he should not be sanctioned for failing to represent Mr. Sear in the adversary proceeding filed by St. Rose. In that lengthy 92-page opinion, the court analyzed a variety of Nevada's ethical rules and determined that Mr. DeLuca violated several of them. As a result, the court sanctioned DeLuca by ordering him to repay the money he received from the debtor. Literally nothing in Sear supports the trustee's opinion vis-a-vis undersigned counsel's request to enter limited scope appearance in this matter. Very much to the contrary, the bankruptcy court explained limited scope appearances, which it referred to as unbundling, were entirely proper and permissible. So let's see what he says. Before assessing the specific rules and statutes at issue, a thorough discussion of unbundling is necessary. Unbundling is the practice of limiting the scope of services that an attorney will provide, dividing comprehensive legal representation into a series of discrete tasks, only someone of which the client contracts with a lawyer to perform. It is growing ever more common in general, and in family law and bankruptcy law in particular. In bankruptcy cases, for example, the client and attorney may agree that not everything that could be done should be done by the attorney. Some things might be left to the client or other professionals. In effect, this unbundling excludes services that might aid or further the client's goals, but with the exception and assumption that the items excluded can be accomplished by the client acting alone or with another, presumably less expensive attorney. The practice can benefit clients by giving them access to legal services that would otherwise be too expensive, and clients may feel a greater sense of satisfaction flowing from a collaborative effort of achieving the client's desired goals. And then it cites some other stuff. So it says the Sear court then offered a detailed and extensive survey of how other courts, bar associations, and legal scholars address the issue of a limited scope or unbundled services. After this review, the court concluded limited scope / unbundled services were proper at least when a lawyer seeks to represent a Chapter 7 debtor without also accepting responsibility for related adversary proceedings. So maybe he isn't doing the adversary proceeding, but I thought he was. I don't I don't know. Okay. In light of the above, the court agrees that the adversary proceedings can be unbundled so long as the limitation complies with the applicable rules and statutes that a lawyer may charge additional fees for adversary proceedings. Okay, great. You're not going to charge her fees. Ultimately, the Nevada court found that attorney DeLuca did not comply with all the applicable rules when he sought to limit the scope of his representation to exclude adversary proceedings. Based on that, he got a sanctioned and was ordered to pay the things back and required him to complete 15 hours of additional CLE classes. All right. So he goes on to say literally no part of SEER is helpful or even arguable supportive of the trustee's position here, contrary to the trustee's argument. SEER held, like the Arizona District Court did in Jacobs and Volta, cited supra, which just means before. Limited scope representations were appropriate subject to certain rules. Here, the trustee council presents no argument and certainly no evidence to support a conclusion like the one reached in SEER. That the limited scope representation proposed in this case would not comply with any ethical rules, legal rule, or any requirement. That fact standing alone should be conclusive. Okay. Get something to drink real quick. In the hearing, he said he was only right. That's what we just read in his filing on noticed the leave to appear is he is representing her in the adversary filing. And in the rules, it says that the bankruptcy attorney is to represent him in everything except the adversary thing. And so he's gonna do the bankruptcy and the adversary, which I don't like I was saying, I don't know if he can do that, but I'm not a lawyer. I don't practice this. Um, Other lawyers have said that they think he's a conflict of interest. Ian Runkle, Law and Lumber, I believe, MG Law has said the same thing. So, yeah, changed his mind, which is what Omar was afraid of in the Maricini case, is Gingras would change his mind. "Oh, I'm not representing her. Oh, but I am representing her." Like, which is it? Alright. Dang it. Okay. I'll get back to this. Started again without plugging up my computer. Oh my gosh, I am so sorry. I'm gonna have to read all that again. None of what he's saying yeah, I think it is still a clear conflict of interest. Um, let's go back over this. All right. So he says that, as both sides have noted, the local rule is already very clear. A lawyer's general appearance for a debtor. Oh, we need to go back up. In addition, the trustee also offers a second baseless argument, i.e., that it appears that Gingras' proposed limited scope appearance would not cover issues pertaining to adversary proceedings. He says, okay, so what? So what? Well, is what you said in the meeting true or not? And or is it now after Laura decided to freak out and saw all the documents and everything that she misfilled out, which you supposedly helped her with, is all wrong. Now she needs your help again for you to help her figure it out and write the things and help her with the thing that you two originally filled out wrong. You're going to now fill it out again together and turn over documents that you did wrong the first time, but now you're going to have it right. Or is it that you're going to help her put all of this stuff through and maybe explain what they mean by these things, but you're not a bankruptcy attorney. So it may get too complex for you. I don't know what the issue is here, but why are you even at the hearing if the adversary stuff is so far down the line? Because he says, both sides have noted bankruptcy case does not mean the lawyer has also appeared in or is responsible for any adversary proceeding. Thus, the trustee simply misrepresents the nature and effect of the relief sought here. In other words, if this court allows a limited scope appearance, or if undersigned counsel simply decides to accept a larger risk by entering a general appearance without leave to impose any limitations on scope or duration, that still would not mean counsel is obligated to appear in any potential future adversary proceedings. But you're there for the adversary proceedings already, right? If the trustee chooses to file an adversary proceeding in the future, that bridge will need to be crossed when and if that event occurs. That is true regardless of whether the current motion for leave to enter limited scope appearance is granted or denied. Let me see here. Adversary hearing in bankruptcy. An adversary proceeding in bankruptcy is a separate lawsuit within the main bankruptcy case. It is initiated by filing an adversary complaint with the bankruptcy court, and it deals with disputes related to certain debts. The proceeding has its own case and may require a separate attorney. There's already an adversary proceeding objection thing happening. But this one says many adversary proceedings arise from alleged fraud by debtor. If it appears that a debtor has committed fraud or violated a court order, the trustee or creditors might file an objection to the debtor's discharge. Also, if the debtor transferred money or property to someone else 2 years or less before they filed the bankruptcy. So Clayton has filed a dispute that she should not be allowed to discharge this. So there is an adversary proceeding in regards to the debt of the Owens v. Eckerd. But he's saying that an adversary proceeding, if there's even one filed, but you're there on an adversary proceeding, in a capacity. Ahoy, Bruce and Batty McBatface. So, yes, mute button. Oh, God, mute button is not my friend. Tech is not my friend. So, okay. He's like, that is too much in the future to know if we're going to even have an adversary proceeding. I don't think it's too much in the future because um, I'm pretty sure there's going to be some adversary proceedings because Laura doesn't know how to tell the truth at all. He says, B, there is no conflict of interest, and the trustees council misrepresents the ethical rules. The trustees' second and remaining argument is that undersigned counsel has a conflict of interest. This assertion is based on the trustees' mistaken beliefs about a statement Miss Owens made during a prior state court litigation in which she claimed to have $450,000 in a bank account. To be clear, if the trustee were to file a pleading alleging Miss Owens did, in fact, have that in her bank account and that she lied in her bankruptcy schedules when she failed to list those funds as a present asset, this would constitute a clear violation of federal rules of bankruptcy 9011. But of course, the trustee has not taken such action, yet he is merely investigating the issue. It's actually she, as he is legally and ethically obligated to do. Yeah, that's what she's doing. But it also goes to you lied in a case where you owe money, and that money that you lied in a case about, you're trying to get discharged to not owing. So she's known to be a lying liar who lies. And how are we supposed to trust that what she says now is the truth? Because one minute she has money, the next minute she doesn't. One minute there's no horse shows and she doesn't ride any horses. And the next minute she's winning horse shows. We have no show horses. Really? Then what were you doing riding Circo 91 in the recent horse show that you had on Instagram? That's not a show horse that you earned money from in the last 2 years? You lied in the 341 meeting creditor people. Hello, Rochelle. She just lies about everything. So he says, in short, you've never done anything in short. There is no pending adversary proceeding involving the $450,000 issue unless the trustee intends to lie to this court or to bring a proceeding without first investigating the claims. This issue is purely speculative and hypothetical. How is her saying she had in an affidavit saying she had this money and now she doesn't have this money in her account? I will also say that when talking to Clayton, I went back and looked at the documentation and it does state, she does state in text or an email or something that the money is from an investor and all that Clayton did know it was from an investor and not her actual money. But then later down the line, it was her money. When she's dating people, when she's trying to put herself out there as an entrepreneur, she's just gonna embellish things. It is gonna be, she is successful in her own right, which she is not, never has been. That's what she loved in Mike Maricini and Greg and Clayton, is that they were just all go-getters like she was. And she wanted to support their dreams and everything, and they would be successful together because she's such a go-getter, and she's so successful in her own right, with all her money, but has never had any money, supposedly. Okay. I've never earned a single paycheck in my life in 35 years. Get the fuck out of here with that. There is no way you have never earned a paycheck in your 35 years. And if I was a bankruptcy person, I would go find some taxes where she filed a paycheck stub, or would let the IRS know that this lady says she's never had a job where she gets paid, but she's had all these jobs. Um, Uncle Sam might come knocking at your door, and that's not a good thing either. He goes on to say, yep. But Clayton did know. He did know, but that's the thing is he knew, but then you stated in another thing that it was your money, not a money market account with an investor. Like, she changes her story to whatever fits her narrative. And as Bruce says right here, why isn't it letting me go back? Starting to think Laura is not a reliable narrator. Well, to Gingras, she is, because her word is gospel. She didn't tell me it was a lie. She hasn't shown me it's a lie. Ugh. Yeah. And, if anybody would have hired her off of her LinkedIn, do you know how pissed they would be when they find out that it's all a lie? Well, I'm just trying to market myself as an entrepreneur. You're trying to market yourself as a liar because either your LinkedIn is true and correct and you are those things, or you've lied on everything to get anything that you have thus far. And she said she bought a property. Yeah, because didn't she say, Bruce, that the properties that she was gonna buy with Clayton, I thought at one point she said that she they ended up because she couldn't buy those, they went and bought another one or others instead with that same money. I thought somewhere that was said. Um, I might have to look, or if there's any investigators in this chat. I thought she said she went and got some property with that investor's money. But of course, she says she bought a property, yeah, because she's successful in her own right. But now she says it's her mom's property. This is where there's going to be things about her moving things out of her name within the last 2 years for bankruptcy, to prepare for bankruptcy. She is a joke, I know. You can go play the clip. She Yeah, she says she bought there's a clip about her buying property, but I thought there was something else that she states that because Clayton didn't get her the properties, they went and bought other properties instead with someone else later, and I don't know if that was the Airbnb property or if that was something else. But, I mean, there's lies everywhere. Alright, so back to this, he says, "But even if it were not, the trustee's position is based on a clear and material misstatement of law, specifically based solely on potential future hypothetical possibility that an adversary proceeding might be forthcoming and might someday be the subject of a trial. The trustee suggests this is mere possibility per se, forbids undersigned counsel from having any role in this case because Rule 3.7 of the Arizona Rules of Professional Conduct, which applies to attorneys appearing in the court pursuant to the local rule, prohibits a lawyer from acting as an advocate for a client in a case in which the lawyer is likely to be a necessary witness." And he said, "What the rule actually says is something entirely different." 3.7, lawyer as a witness. A lawyer shall not act as an advocate at trial in which the lawyer is likely to be a necessary witness, unless the testimony relates to uncontested issue, the nature and the value of legal services rendered or the case, or disqualification of lawyer would work substantial hardship on the client. Well, wouldn't an adversary proceeding possibly go to trial? I don't know. So, okay, it says at trial. And the bankruptcy case could be, I don't know, it could cause you to go to trial. So I don't know. By its own terms, Arizona's ethical rule never prohibits a lawyer from assisting a client in a pretrial matters simply because the lawyer's testimony might later be needed at trial. Merely states that if the lawyer is likely to be a necessary trial witness, the lawyer cannot also act as an advocate at a trial unless one of three exceptions apply. The rule is simply irrelevant here for multiple reasons. First, there is no actual adversary proceeding pending in which undersigned counsel is likely to be witness. The mere hypothetical possibility of potential future action does not implicate the rule in any way. Second, even if there was an adversary proceeding filed, that matter is not scheduled for trial. The rule does not prevent a lawyer from assisting a client with pretrial preparation, even assuming the lawyer becomes a trial witness. Well, we'll see what the judge thinks about it. Third and finally, if a future adversary proceeding was filed, which could only happen if the trustee intentionally violates a rule, and if the case were set for trial, ER 3.7 would still not preclude the undersigned from acting as both an advocate and a witness at trial because the exceptions of both 3.7a and 3.7c would apply. The underlying issue related to the 450,000 will not be contested issue because the facts relating to this point are undisputed, and even if they were not, disqualifying the undersigned from representing Ms. Owens would work as substantial hardship since she is unable to afford private bankruptcy counsel. Well, she was doing this pro bono or per se by herself before. She can continue to do it now So it's not any more of a hardship when she first filed this case. It might be different if she entered this case with an attorney and then that attorney left midway. But she started this without a lawyer. It's not gonna be a more s it's not gonna be a more substantial hardship than it was prior to you being on the case. It's gonna be the same, and she should have known about all that before filing for bankruptcy, and if she didn't, that's on her. Conclusion: the trustee's objection to undersigned counsel request to enter a limited scope appearance in this matter has no merit. The motion should be granted and the trustee's objection overruled. Signed, Gingras. And they served the pleadings. Something Yes, she needs a refund on all self-help books. Yeah, and Gingras doesn't adhere to professional rules of conduct. He says he does. And I'm not saying he's not right on some of those things. Yeah, and she gets you have to report that her parents pay for it, that her parents pay $300 or whatever a month to berries. I don't know if it's 300 or not. That's just what people have said, but pays for her berries memberships, pays for her to enter these horse competitions. They they pay for anything that she needs for these riding competitions. They pay for her hair, her nails, or she may not have nails. Um, they pay for her Botox, her sculpting. Technically, they pay for her HCG as well because it's not ever been her money. She's never been paid a day in her life from any company. So, they pay her basically her rent, they pay for all her groceries or her eating out expenses, they pay for gas if she drives, um, they pay for flights. So, why can't they help pay her debts? That's what I would say. If they can pay for all of this stuff, instead of you spending all this money on these things, why can't they help you pay your debts off? Or why can't you get a fucking job? Because there's no reason you cannot go get a job. Yeah, I'm interested to know on loan applications, how she got the money marketing, accounts. Yeah, the parents are bankrupt too, and they can't pay their own stuff, but they're still paying for her stuff right now because she still goes to Barry's, so that's still being paid for. She, I'm sure, gets her hair done. They pay for her eating, which she might not eat that much right now, but is that why she's lost weight? Is because her parents can't afford to buy her food anymore? Like, I don't know. And her parents' debt is so messed up that they decided they didn't wanna even submit all their documents because maybe it wouldn't look good and they could get in trouble. They just decided, "You know what? Never mind. We're just gonna abort the bankruptcy mission." Yeah, like cleaning and stuff like that. No, no, you did not spend that on household items. Clothes, I mean, clothes probably aren't that expensive. She has the same clothes, and She wears the same damn thing to court every time she goes to court, so, she only has the one outfit. Um, but she's going to these horse riding competitions, and they're paying for that, so even though the parents are bankrupt, they're still footing a lot of money for her. Transcripts, the fees that she pays for transcripts, her parents had to pay for that because court fees being waived doesn't mean you get transcripts for free, I don't believe, from my understanding. So she had to still pay for transcripts. Maybe Gingras paid for those for her, who knows? Okay. Black dress, black chair, black leggings, black flats, black turtleneck. And we know she didn't steal it from Jan's closet because dang, that would be swallowing her. And it is her turtleneck dress or whatever doesn't. Maybe it is Jan's and she wears it as a dress, but it's actually Jan's sweater or turtleneck. It's supposed to be a shirt, but Laura can wear it as a dress. Who knows? Okay. So that is what we have on the bankruptcy. Yeah, the villain attire. It's funny. I mean, does she think she is dang it, what was his name? Steve Jobs? Does she think she's Steve Jobs who has the same outfit every single day? Who had the black turtlenecks and stuff? Is that who she thinks she is? But okay. Let's actually go through and watch the creditors thing. And then I was going to do Hey Rob's thing because a lot of thoughts about that shit. Yeah, she can wear whatever she wants as long as she provides proof, which she can't. All right, let's go to the meeting of creditors on February 9th, 2026. I am going to speed this up. If I can. I'm gonna at least put it at 1.25. All right. So let's do that. So we're going to share. And this is on Schnitzel's channel. Nope, I actually need the audio here. Let's go full screen of that. All right. got closed captions on and everything. And I'm going to mute myself and unmute myself when I want to talk so that there's not an echo, because I don't want to deal with my headphones audio thing right now, because it's going to probably cause technical problems. So let's start this.
Times for me to forget to hit the button. I didn't hit the recording button. Thought I did. All right, we got to start over. Luckily, we didn't get too deep into it. This is a call in the Owens case, Laura Owens case 25-11801. I'm sorry, if you don't mind, I have to swear you in again. Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Would you state your full name for the record, please?
Laura Michelle Owens.
Ms. Owens, do you understand the importance of the oath you just took?
Yes.
Is your address correct as it's listed in your petition?
Yes.
Is that where you currently reside?
Yes.
Did you receive the bankruptcy information sheet I sent out?
Yes.
Had you lived in Arizona at least 2 years before you filed this case?
Yes.
In the past 8 years, have you filed another bankruptcy case anywhere?
No.
Did you review all of your bankruptcy forms and paperwork before you filed it?
Yes.
When it came time to sign any of those documents, did you physically sign them yourself?
Yes.
Do you understand that you signed those documents under oath?
Yes.
Are all of your assets identified in your schedules?
Yes.
Are all of your creditors listed there?
Yes.
Are you paying or do you owe any child or spousal support obligations?
I do not.
Have you filed tax returns for all years up through 2024?
Yes.
I got a 2024 tax return copy from you. What is the status of 2023s? That would have been another one that I asked for.
2023 should have been sent as well with the 24. I know my civil attorney, David Gingras, had been helping me, and I thought he sent that one over.
Okay. Can you guys confer after we deal with the meeting today and follow up and get that to me? Make sure
Yes.
I get it. The 2024 tax return copy that I did see, was that a true copy of what you filed for that tax year?
Yes.
All right. In the past year, have you made any payments to any family members or friends?
No.
In the past 2 years, have you sold, given away, or otherwise transferred anything?
Yes.
Okay, and you answered yes to that on my trustee questionnaire. I don't remember seeing anything about that in your statement of financial affairs, but what are you talking about when you say yes to that answer, to that question?
Yeah, I started an LLC called LizMax Investments LLC.
Okay.
And it was supposed to be for investment properties, and my mom ended up being the one who provided the down payment for a property, and she ran it herself. It wasn't something I ended up having anything to do with, so I gave her the LLC. I just took my name off of it.
Okay, and if we've already done some preliminary work in here, and if I understand it, and correct me if I'm wrong, the real estate that was the investment in that LLC the LLC no longer has it. The bank took it back.
Yeah, it was forfeited.
Okay, is that the only transfer that you that you made to any insiders, family members, friends?
Yes.
Or rather, that was the question. Was that? I'll ask it again. In the past 2 years, have you sold, given away, or otherwise transferred anything? So that's it. Whether it's an insider or not, that's the only thing you've transferred in the past 2 years?
Yes.
In the past 3 years, have you been a plaintiff in any personal injury litigation or some other kind of claim settlement?
Not personal injury. Nothing I would be entitled to money in.
Do you have any claims like that available to you that you've not begun to pursue yet for whatever reason?
No.
Do you currently have any ownership interest in real estate, whether it's through another entity or personally yourself anywhere?
No.
Are you the beneficiary in any trust or other kind of an estate?
No.
Have you gotten a divorce in the past 2 years?
No.
Okay.
Okay. So, okay, I should be unmuted now. So, good night, Henrietta. The question about do you have any child support or anything like that coming to you, or that you have to pay, or have you been divorced? That made me laugh. He's just going through the basic questions, right? But I'm like, no, sir. The reason we are here in this bankruptcy case is because nobody wants to be with her and have children with her, and she only has imaginary babies. That's what this bankruptcy case is because nobody wants to be with her. So no, she does not have any divorces, and she only has imaginary babies. that never existed. And then here she says that the only thing that they have sold or she has transferred is that Airbnb Liz Max house thing, but her mom bought. But in the last meeting, or one of the last meetings, she said that she had also sold like a old saddle or something. So she didn't admit to selling that in this one. So those were some things that stuck out to me in this so far. And it's interesting that she says that she's gotten everything right now that the court has given to her and has sent to that address or the email or whatever on file. She's received everything. But she also says in other things that, well, I never received that or I never saw that. Well, why are you not seeing those things? Or you're denying that you were ever given these things, but you receive everything else. It's because you want to delay. All right.
Okay, I don't have any other questions, and I'm going to open this up. But I don't think, based on the last meeting, that most of these people want to ask any questions. But I see Ms. Jaimo from the UST is here, and I'll give her the right of first refusal. Did you want to ask any questions, Ms. Jaimo?
Yes, Mr. Haley, do you mind if I have, maybe it's 10 minutes, is that too long?
That's fine. This is the last one of the day.
Okay. Okay, so Ms. Owens, I'm an attorney.
It in fact is not just 10 minutes. It probably would have been if Laura could just give clear and concise answers. But she doesn't know how to do that. So she draws shit out. Just like she did on June 10th.
With the U.S. Department of Justice, the U.S. Trustee's Office, and we oversee these bankruptcy cases sort of as a watchdog. And I had gone through your bankruptcy documents, and I just want to ask you some questions about some of. But before I do, I just want to make sure. So, is Mr. Gingras that's on here? Is that your attorney for the bankruptcy case? He has been helping with the adversary proceeding, but he's not my bankruptcy attorney. No, I don't per se, but he helped me because I confused some of the filings.
I can clarify that if you need me to answer.
Yeah, yes, please.
So there's an adversary proceeding that's attached to this. I represent Ms. Owens in the adversary proceeding, but only that, not in this main bankruptcy case. I'm obviously involved in the adversary part of it, and I've been communicating with Mr. Haley and his counsel as well. But I've not appeared for Laura in the bankruptcy, and I don't intend to if I don't have to. But I'm just on standby for now.
Okay, so
he's just on standby for now. He's representing her in an adversary proceeding. And he's not going to enter an appearance unless he needs to or has to. But in his filing, he said that there was a hypothetical adversary proceeding, that wasn't even in the sphere right now of the bankruptcy case. But here he says he's a part of the adversary proceeding. So is there an adversary proceeding or is there not? Gingras? Are you not counting that adversary proceeding? You're thinking of a different adversary proceeding. It's just so infuriating.
So Ms. Owens, I'm probably going to end up after this noticing your deposition and formally asking you for documents. So that's something I should ask of you personally because you don't have an attorney, correct? Yes. Okay. So I want to start with, I see that recently you amended the schedules of your assets to include a couple of Bank of America's accounts and an E-Trade account. Is that correct? Correct. I listed them in the wrong spot on my filing. Okay. So what had prompted you to file the amendment? Were you just going over them and realized, oh, this is not in the correct place? I believe that Mr. Tate had questions. He was assisting Mr. Haley, and he had questions. And so then David had helped me with making sure everything was in the right spot. So I guess, you know, in re-amending the schedule.
Ms. Jaimo, I think you might mean Terry Dake.
Yes. Oh, I'm so sorry.
Okay,
I'm so sorry. Yes.
You said Tate. I just wanted to make it clear. Okay.
Yes. Sorry about that.
Okay. So having.
So she says right there, Gingras helped her put everything in order in the right places on the amended schedule thing. And we find out later that that is still wrong. So the first one is wrong, which she probably had Gingras's help. The second amended one that she did is also going to be wrong. And who knows what this third one's going to be with him as officially her lawyer. I also like that she let her know there's going to be a deposition. This is not going to be the worst of the worst. Your deposition is going to be where it's at. And she let Laura know that she's kind of like the watchdog for in the case. You should have really understood what that meant.
Seeing that you amended the statements to identify those accounts, do you have copies, or can you easily get copies, like electronic copies of the bank account statements for the Bank of America account and the E-Trade account for 2025 and 2024?
Yeah. Mm-hmm.
Okay, are those accounts still open?
The E-Trade one is that I think is the same as Morgan Stanley. I think it is. It is that I think Morgan Stanley owns E-Trade. I think that's what it should be listed under. Do you see that? It's like
I'm just looking at your schedules, and it indicates E-Trade account.
Okay, then that's what I'm thinking of for the Morgan Stanley. I don't have like another. I know that's confusing what I just said, but I definitely do not have another bank account that's not listed.
I definitely do not have another bank account that is listed. Definitely do not. So don't even think that I have one. This is it. Don't go looking, because I definitely do not have any more. Do you have a Cash App? Do you have a Zelle account? Do you have Venmo? Do you have Apple Pay? Google Pay? Chime? Do you have any of that? Do you have Square? Because those are all considered bank accounts. And the trustee did not ask for those things, which sucks. I want the trustee to know she needs to ask for that stuff, because that could share a whole shit ton of information. And I'm wondering if they just use Jan and Ron's credit cards to pay for all of Laura's stuff, or does Laura have that card in her name? Or is it sent to like her Cash App and Laura pays things from there? I'd be interested to see how the money exchanges the hands for Laura's stuff to get paid for. They all just share an Amazon account? Because maybe what they need to do in her criminal trial is get Jan's or Ron's Amazon account, not Laura's Amazon account. Oh, but Bruce, none of the GoFundMe money has gone to Laura. They said that. And Gingras doesn't have a boat, so I don't know what boat they're going to use. They're going to have to use a saddlebag and not a briefcase as well. All right, continue.
The E-Trade accounts What was your question on that? I'm sorry.
If you can get copies for 2024 and 2025 of the statements.
Yes.
Okay, so that's not going to be a problem. So I'll be asking that of you in formal document request.
Yes,
Okay.
that's no problem. I can get that. Yeah.
Very good. And I see that you added that you have a potential tax refund of about $891 for 2025. Is that correct?
Yes, I think that was for 25.
And where did you come up with that figure? That precisely?
I did it on Credit Karma. I did like my taxes on Credit Karma, and they came up with that figure, but then I never got a refund, so I was just presuming it was.
I can shed some light on that. That's the Ms. Owens, that's the amount that's listed on the 2024 federal return that I got from you. So it's I assume it's your testimony that you never received that.
No, I did not.
Did you file that timely? You filed that 2024 return when on or before the deadline, or maybe the extension deadline, which would have been near the end of 2025?
Yes.
Okay.
So speaking about the tax returns, Ms. Owens, will you permit Mr. Haley to share copies of the tax returns that you provided him and are going to provide to him with me?
Yes, absolutely.
Okay, so Mr. Haley, you have no problem sending those to me, correct?
I do not.
All right, thank you.
So supposedly she was supposed to get like $891 back, but she never got it. The only reason that you don't get your returns is if you owe like people money or you filed wrong, but also how and why are you filing a tax return if you have nothing to file for? Like, it'd be different if she had a kid or was going to school or something like that, and she had, like, those things to file with it. Or if she was on disability and she was going to school and all these things, even though disability and all that is not, it's not taxable. If you're on disability, you're not paying taxes on that. So why didn't she get her money back? Has me wondering. And why is she filing returns if she what why is she filing an income tax return if she's gotten no money? So that stuff's going to be interesting. And it makes me I've never used Credit Karma for tax returns, but it makes me not want to use Credit Karma for tax returns. This is not a good advertisement for Credit Karma.
Right. Did you have a CPA or accountant or any financial, bookkeeper, somebody assisting you with your tax returns or not?
No, I just used Credit Karma.
Okay. And I see that in your schedules, you listed debt to Cherry Tech, and that's a lender for Innova Med Spa, correct?
Cherry Tech is a lender that I used for Botox and for like a skin firming treatment that I got. I don't know if they're with Innova Tech, but that's not what I used it for. It was pool sculpting was the one I used it for. I would provide the name of the place that did that as well.
Okay, so you never obtained any loans from Cherry Tech based on services or products that you purchased from Innova Med Spa?
Not that I'm aware of. I mean, I've gone to a lot of places for Botox and procedures, but that's not where I think I did anything for Cherry.
Okay. So do you have documents that show, invoices, copies of that sort of thing that will show the debt that you owe to Cherry Tech that you listed here in the schedules?
Yeah, I should.
All right. So those are also documents that I'm going to ask for in my formal document request. So, okay. And just be aware, please don't destroy any documents right now while you're in bankruptcy. It's crucial that you keep all your documents. We're going to be asking for some documents. And even if we don't ask for them, we shouldn't be destroying anything right now.
Okay. Yeah, I'm not.
Okay. All right. So
I don't think she's going to destroy anything. I think she just might not hand over things or fudge things. Maybe she's learned not to do arts and crafts and she won't in federal court. But I just... And she brings up the Innova thing so we know that when Innova takes the stand in the criminal case, there's going to be questions of, oh, it was just, she only went for you for Botox and this cool sculpting stuff. But apparently she's gone many a places for her Botox. Who's paying for your Botox? Was that on the parents' bankruptcy filing? Is they're paying for Botox and cool sculpting for their daughter?
On Schedule I, it indicates that you have zero income, so no income from wages or operating a business, correct?
Correct.
And so for what time period were you stating that you had no income for?
I mean, I haven't ever in my life had like a 1099 or W-2 job, but I've, really been supported by my family.
So never in your life have you received a 1099 or a W-2 from any business, including your own businesses?
Correct. Never.
Have you ever received any kind of tax form like a Schedule K-1 that indicates that you have a certain share of earnings from a partnership or an interest in an entity?
No, I know that the LLC, my family's LLC business taxes are filed on a Schedule C. And that's all I know.
But you are the owner of at least 4 entities that you identified in the Statement of Financial Affairs. You are an owner of at least 4 entities.
I think that I would consider it to be like 4 I was associated with. Maybe David could offer some clarification because he helped me answer that question. David?
Well, let me just pipe in here. Either Mr. Gingras represents you or he does not. So
Like she's in charge of this meeting. Ma'am, no. No, you are not. You're not in charge. David. Answer this, because he's the one who helped me answer this. Why is Gingras helping you answer a question that you should know the answer to? But Bruce said Cherry Tech was for Botox and cool sculpting, but she doesn't say what she did with Inova, which is interesting. So, yeah, I wouldn't say anything about Inova either if that's where my HCG came from, because they're going to use it in there. This is why she does not need to do Zoom and things like that, because she's just like that. David. Like, oh my God. And she's like, But you know what? Gingras has not corrected Miss Camo. He has let her call him Gringus because he doesn't really care. Her credit's got to be god awful too. Not to say much, mine is bad too, but she's like, he's either your attorney or he's not. So no, he's not. But now he wants to be.
I'm not comfortable with having Mr. Gingras step in as your counsel. So if he's not your counsel here, unfortunately, he cannot be advising you on how to answer that. I guess, do you have a copy of your Statement of Financial Affairs in front of you?
He's not supposed to be advising her of how to answer that if he's not your attorney here. But he is. And he's going to be in the background doing all this. So what's the difference in him being on record and not? I mean, it's going to be a dumpster fire either way.
I do not, but I have always thought I was the manager of LLCs, not an owner, and I have not ever filed them on my taxes or anything.
Okay, just because I want you to be aware that if you look at your own statement that you filed under oath, you check off the box that you are an owner of at least 5% of the voting or equity securities of these 4 entities: Quartet, Lizmax, Keybacker, and Stylet. So is that incorrect information that you put on there?
I thought it was if I had been known to have any identity with those, and I knew they were ones that my name has been associated with over the years, and I was trying to cover my bases in terms of listing which ones I've been a part of.
Okay, and also I looked at your LinkedIn account and it indicates on.
No, you didn't think that was what any of that meant. Oh, I just if I was a part of it, I thought I had to, like, list it as I'm, like, the owner person if I've ever had a part of it. Um, I don't list myself as the owner of a place that I rent out of to do my massages. I don't claim to own that building because I am associated with it. I am my own person. And hello, Claire. It's okay. I just thought um uh if and why would you want to use her as the face of your businesses with her reputation right now? It's stupid.
The LinkedIn account that you're an owner, an executive with those entities. Is that
I mean,
not?
they're really not comparable. I mean, I'm trying to market myself as an entrepreneur, but it's not like I've got these businesses that are,
You're trying to
without
lie.
level.
Okay, I'm not asking yet about whether they're operating. I'm asking about whether or not you are an owner and you hold yourself out to be an owner of these entities on your LinkedIn account and on your sworn schedules in this case. So, and now you're saying you're not an owner. You were just, well, I don't know what you were. So were you an owner of the 4 entities?
I mean, I'm more like, they're my family's entities, and I'm more like the face of my family's entities with those businesses, I guess.
Okay.
Also, if they pull the LLC, like people that applied to have their name on that LLC and those businesses, is she going to be on that paperwork when they sign the stuff to be for these businesses? Her name is going to be on them. Maybe not anymore, but she originally was on them. Yeah, she put her email signature. Oh my God. Just the face of the company.
Well, we can.
That's the best way I would say that. I know I'm not answering it well. I'm not trying to not be truthful. I genuinely don't know how to explain it.
Okay. Well, then you'll have to make sure I'm going to recommend to you.
I need to really listen to Jack's thing because I'm not trying to not be truthful. What the fuck is that? I'm not trying to not be true. Like, who? I'm trying to be honest. I'm telling the truth. Not that I'm not trying to not be truthful. What the fuck?
That you go back over your schedules, that you sign up for penalty of perjury and make sure everything's accurate, because you have in your sworn schedules stated that you are an owner of those entities.
Okay, I will go back and reevaluate that. I'm sorry.
Okay. All right. So on Schedule I, which is where you were supposed to list your income on the bankruptcy schedules, you added a line item on 8H for family support for food and living expenses, and you put 0. So was that a mistake? Do you receive any kind of family support to pay your expenses, your monthly expenses?
They just pay them out of their money. I don't, like out of my parents' pension and Social Security. They don't give me money to pay that. They pay it directly.
So what are they paying directly when you say they pay it?
Well, I live on their property, so I mean, you could technically say they're paying, housing and for my food.
Okay. What about your car payments?
We share a car. They pay for my car.
Okay, so they directly, because you are the sole owner of the.
I'm the sole owner, but they're paying for it right now because I can't afford to make the payment.
Okay, so that's something that you do need to specify how much it is, even if you have to come up with an estimate on Schedule I of your schedules. You have to indicate how much money they're front.
Also, yeah, she did have these things listed in her email signature with all the best. But which they don't do anymore. But imagine if we lived still in the time, which somewhat wish we did live in the time a little bit, of you weren't allowed to use a credit card if your name wasn't on that credit card. So she has money in a debit account, or maybe it's a credit card. I don't know how she got the credit card with she should have shitty credit, so I don't know how she was approved for that, with the signature and everything like that, and your ID matching all of that. It's Laura should never have been able to use a card ever if it's her parents, because she would go to the store and it would say Jan or Ron on there. Um, yeah, their podcast, if they would have they could have told their side of the story about the paternity case on their podcast. They're like, "Well, Gingras is like, I wanted her story out, and they're only telling Clayton's story." And they could have told Laura's story on her podcast. They chose not to. Yeah, it's supposed to be only the card holder can use the card. But yeah, your mom, her mom takes her to the store. I mean, Laura doesn't go anywhere without her mom. I go shopping with my mom too, but we have two separate transactions. But I mean, if we wanted to put it all on one, we could. All right, back to this.
For you for your expenses.
Okay.
Leave it 0.
Okay.
So you'll need to figure that out and amend Schedule Y, okay?
Okay.
So, and I'm assuming your parents also pay your car insurance?
Yes.
Okay, so you don't pay any bills for yourself?
No.
And you say that are you saying that you've never earned any income on your?
Also, why does she have a car if she has free Uber for life? Why do you need a car? I mean, I guess it's more convenient, but still. You don't have to pay for car insurance, you don't have to pay for gas, and you get free Uber? Why do you need a car?
Your own ever?
Correct.
Okay, how old are you?
I'm 35.
So 35 years, you have never made any income on your own to pay your own bills.
I mean, like I said, I'm the face of my parents' businesses, so they've, paid my living expenses in exchange for me helping them.
Okay, so that's kind of a compensation for your services then.
I mean, I don't take advantage of it, but
well, you're providing them with services.
Nobody asked if you took advantage of it, but you do take advantage of them. So you're lying right there.
They're compensating you by paying your bills, is what you just said, right?
Yeah, exactly.
Well, then you better figure out how you're going to want to disclose that in these schedules, because that is a form of compensation. I would recommend that you really read through what the schedules and statements require you to disclose.
Okay.
And we'll go more into this because I'll probably have to take your deposition, but I wanted to make sure to give you an opportunity to amend anything that you were contending was just an innocent mistake. Okay, so the biggest issue I had was that, regarding this claim of yours that you don't make any income. So you are aware that on the Statement of Financial Affairs, you did not disclose receiving any income of any kind for 2023, 2024, and 2025 through the date of the bankruptcy filing. You're aware you did that, right?
Yes, I didn't understand that how I was supposed to say if my expenses were being paid for.
No, not on your expenses. Right now, on the statement. On the Statement of Financial Affairs, on items number 4 and 5, and you could take notes if you want, so you can follow up and look.
Okay. For this. I don't have a pen, but I have my phone here. Sorry.
Yeah.
Which schedule?
So it's not the schedule; it's the Statement of Financial Affairs.
She should have been taking notes this entire time. Every court hearing she's at, she should be taking notes so that she knows what the hell is going on, especially when she's pro se, pro per, whatever, no attorney, because you don't know what the hell you're doing. Also, she wants her to go back and read through these schedules because she's apparently read them wrong, and apparently so has Gingras if he's the one who helped her fill this shit out. So neither one of them understand it. Or Laura's lying to Gingras, which all of it could be true.
And you've recently amended it, so it's items number 4 and 5 required you to disclose all income you received, even if it was non-taxable income.
Okay.
It was 2023, 2024, and 2025 up through the date you filed the bankruptcy petition. Okay.
Okay.
So I guess let me ask you: does your 2024 tax return indicate that you received any type of taxable income at all?
No, I know I was under the limit, but I just thought I had to file it anyway.
So what do you mean you were under the limit? Under the limit?
For like, I know there's like some, if you make below a certain amount, you don't have to file, but I thought I did need to file anyway.
Okay, but so it wasn't zero though. So you might have been below the threshold for there to be a tax, but you did make some money. Is that what you're saying?
I mean, not to me. I mean, if you're going based on what my parents paid for, then yes, but I didn't make $1 last year.
I'm talking about now 2023. It's probably 2023.
In 23.
Yeah, put it on 2023.
It was the same situation.
Okay, well, I guess I'm a little confused because so your testimony is that in 2023, and you're saying now under oath that you made no income whatsoever in 2023. Is that what you're saying under oath right now?
I think maybe I don't quite understand what the question is, because it goes back to the LLCs with my family and and just how I'm understanding the question. All I've had has been they've compensated me by paying my expenses, and so it's been the same. So nothing has changed. I just want to make sure I'm answering it correctly, but I'm not sure I am.
Okay, you were asked on the Statement of Financial Affairs to disclose all income, whether it was taxable, that you received from employment or from operating a business or from any source really whatsoever, and that would actually include gifts. You declared zero for 2023. Is that a truthful statement? Now that you're sitting here under oath, I just need for you to tell me if that's still a truthful statement.
Are you referring to like if they gave me a certain amount of money, then is that what you're referring to? Because there's nothing like tangible like that. They didn't, say here's $10,000 and that would be income. I mean, like my bank statements will show. It's not like I had anything in there.
Well, I guess I'll have to see your 2023 tax returns.
Oh yeah.
Did you declare any income at all on your 2023 tax returns?
No, not that I can recall, unless I was saying that my parents, like there was an equivalent to what they were giving me, but I don't think I did that.
Okay.
Which it sounds like she should have been saying that her parents give her that. To the IRS, and they didn't. Her parents should have been 1099ing her. One, because it saves them money on their taxes if they say that they're paying money to Laura. It actually hurts them not to 1099 Laura. As somebody, because even like me, if I for some reason have to pay another therapist and I pay a therapist a certain amount of money a year, I have to 1099 that therapist so that I can show that that money didn't stay with me. I paid that money out. So it looks like I have this much money, but I actually gave this much money away to this person and I 1099 it so that I don't get hit with the taxes for it. So it actually is hurting their business by not 1099ing Laura. But they're trying to just get away with not having her do anything, looking like she's a bum.
So I'll follow up with that in deposition, but I do need to understand, you're saying that now, But are you aware that what you're saying right now is completely inconsistent with the testimony you gave under oath in the Owens versus Eckhart paternity case? Are you aware of that?
Yes. Are you referring to? Can you please
More
explain?
specific? Absolutely. So you were deposed in that paternity case on March 1st, 2024, correct?
Correct.
And in that deposition, you testified under oath that in 2023, you and your mother received about $83,000 of total income from the podcast Nobody Told Me.
Mm-hmm.
You recall testifying to that?
Do
you recall testifying to that? Yes or no?
Yes.
Okay. So was it true when you said it then?
The podcast was making that much money, yes.
Okay. And in that testimony, you said you received half of that. So that's about a little less than $41,000, little more.
But it was nothing that, our businesses have been such that we paid the expenses out of like what's been taken in. So it's gone right out.
Right, I understand. And so you would say that there was no net income. Is that what you're trying to say?
Yes, we had huge losses from the businesses. Yeah.
Okay. Regardless, on the statement of financial affairs, it told you to disclose all gross income, not net income. And you did not disclose that for 2023.
I'm not sure it made that in 23. I think in 23. In 23, I know I testified that, but I was thinking of the previous years. It definitely didn't make that in 23.
No, you're incorrect. Let me correct you. In 2024, you testified, and the question was posed to you in 2024: how much money did you make from this podcast? In 2023, and you testified under oath that in 2023 the podcast generated $83,000 of income, of which you received half. That was your testimony under.
Well, what I was entitled to if I needed to touch it or if I needed to do something with it. Again, in fact, I did not understand what the questions were, and I'm trying not to answer anything I don't understand.
She had an attorney when she did her deposition and was asked these questions. So her saying, I didn't understand the questions or how to answer things, you had an attorney there. And she's just like, what are years? What are years? Like, when people ask me about my income, I tell them that I make what I am entitled to. I don't tell them what I really have, just what I'm entitled to. Like, bitch, nobody's asking you about money you're entitled to. A lot of us think we're entitled to a bunch of money that we don't ever get. I was saying what I was entitled to. Okay? And money that you can touch. So you did make that. You could touch that money. But it wasn't like it didn't go into my account, so technically it's not mine. Oh, good God. She is not this obtuse and stupid. She's just playing dumb. She's acting, and she's awful at it.
Okay, well, again, I'm going to remind you before we meet again for a deposition that I'm going to have you come to my office here. You might want to consider going over your answers to the statement of financial affairs. Because you're supposed to disclose all gross income from 2023, 2024, and 2025. Also, when you testified in your deposition on March 1st, 2024, you testified that your horse business, and I believe that's Quartet. Was that what the name is?
That my parents' business is Quartet Farms. I'm a manager of it.
Yes, but you hold yourself out to be the owner of that on LinkedIn, correct?
As the manager. Like I said, so much of this is just semantics, and I don't know what I'm talking about. I'm not.
Do not play with me that you don't know the difference between a manager and an owner. That is so stupid. Nobody buys this bullshit. That you don't know the difference between an owner and a manager. You know what you're doing. You would have put manager if you were a manager. Nobody is saying that they're an owner of McDonald's if they are a manager at McDonald's. It's bullshit. Ugh. And yes, she pledges to earn that money, like Amber Heard. You know, pledge, donate, earn, expected.
Trying to be dishonest or like hide.
Right, but you understand that what it means, there's a difference between a manager and an owner, and you do.
I didn't know that. I didn't know.
On your LinkedIn profile, you don't know.
I didn't know on my LinkedIn. I didn't know there was a difference between a manager and a member on LLCs. I didn't know what the difference was.
Right, I'm talking about your LinkedIn profile. You hold yourself out to be an owner of Quartet. Is that not true?
Correct.
Correct what? It's not true that you lied on LinkedIn? Is that correct to say you lied on LinkedIn?
I think I didn't understand what my title was, so I guess technically, but it wasn't something that I'm trying to, it wasn't like I deliberately said that. It's my family's business. I think of it as like my family's company.
All right, well, the question is, you state on your LinkedIn profile that you're an owner of Quartet.
Yes, you did deliberately say that. You deliberately did that. But I didn't deliberately like say that and put that on there. Yes, you did. And you stated so earlier because you were trying to put yourself out there as an entrepreneur. You're either an entrepreneur or you're not. And what, you know what? Most people, like when you see like on these dating shows and other reality TV where they're like entrepreneur, you know what that usually means? Jobless.
Is that true or not?
Then I guess now when I'll change my LinkedIn. I didn't understand.
Okay. So anyway, you testified on March 1st, 2024 that the horse business, Quartet, made $144,000 of income, and that was split between you and your mom. Do you recall testifying to that?
That amount was made, but probably $400,000 in losses.
Okay, that's not what I'm asking. You gotta listen to my question. I asked you, do you recall testifying that you and your mother split $144,000 of gross income that was generated from the horse business in 2023?
I mean, I don't feel like I'm answering these questions the correct way. I mean, it's just that
the only correct way, Ms. Owens,
his bank account, it like didn't go to me directly. Like, yeah.
The only correct way for you to answer is honestly. Okay, so
but that's what I'm trying to do is answer as honestly as I can. And I don't know a lot of the stuff that you're asking me. The answers you.
How do you not know the answers to your own to your own finances, to your own life? The only way to answer is honestly, well, I just don't, I just don't understand anything. And oh my God, I'm just going to have a panic and a meltdown. No, you're panicking because you can't keep your shit straight because you needed to say it for this. You need to be the owner over here, but you can't be the owner over here. It's fraud. Yeah, her title is irrelevant, Bruce. I agree. What matters is what is the LLC's operating agreement. Yeah. Was her name on these LLCs? And if it was, when did they get transferred? Because I'm betting it's in the last 2 years. And she pulls Amber Heard's style shit out of her ass all the time. And I don't know why she thinks it's going to work for her, because it didn't work for Amber Heard. It's ridiculous what she's trying to sell to people. I don't know why she thought she was going to be able to pull this shit off. Nobody believes her in anything.
My family's businesses, and I don't know.
Okay. Well, that is what you testified to under oath in your deposition in the attorney suit, so we'll have to deal with that later. But that is extremely at odds with what you testified to under oath in meetings in this case.
Correct, because I presumed that was like what my equivalent would be in terms of what I had done and brought in for work.
Okay. The other testimony that you gave, which is actually at trial in front of a judge on June 10th, 2024, you testified in front of a judge that you were, at the time of trial, 2024, making $200,000 a year approximately. Do you recall that testimony?
Correct. Yeah.
And now, is that truthful testimony?
I'm not comfortable answering that now that I realize how much I have messed up my other answers, and I want to speak to an attorney before I answer, because I genuinely.
This is her trying to plead the fifth. I want to speak to an attorney before I answer that question. Because it's another version of perjury. Although she was like, that's just mine and my mom's split money, but we didn't actually get that money. So yeah, we're supposed to make that amount of money, but because we lost so much money, we didn't actually make that money. It's talking in circles. It's the equivalent to what I brought in. Nobody asked you what you brought into the business. Like, anybody that's taken some elementary, like 5th graders could answer this question on what this stuff means. Definitely middle schoolers are taught about net and gross. Give me a break.
Don't know how I'm trying to explain that income has been split up in my family.
Okay, I'm just asking if at trial you testified in front of the judge that at the time you were making about $200,000 a year. And I'm just asking if that was true.
Yeah, that was exactly what I thought at the time. I mean, I know what the business is generated, so.
But you didn't report that on your sworn bankruptcy.
But that's what our family's business is generated, and I have been like the face of the business, is doing a lot of the work. So that's why I said that amount. I mean, I still feel that was consistent with what they made, and that's why I said that amount.
Okay. Well, again, we'll have to go into this more in a deeper way when you come here for a deposition. So are any of the entities, let me just go by each one. Quartet, is that still operating?
Yes.
And is Lizmac still operating?
No, that needs to be closed officially, but it's not. Your property is forfeited.
What about Keybacker? Is that still operating?
No.
And Stylete was never operating, correct?
No.
All right. So, but Quartet, and that's the overselling business? Mm-hmm. Yes?
Yes.
And that's still operating?
Yes.
And do you still work for that entity?
That entity is not doing anything actively right now.
That didn't answer the question. Are you doing anything? Are you still working for that entity? That entity isn't doing anything actively right now. Well, that entity and you were doing stuff in November of 2025 because you went to a horse show. So just because you didn't have a horse show yet in 2026 that I know of doesn't mean there hasn't been. But that entity is doing shit. And you've also had to travel for work in 2025 in your criminal case. So what's the truth and what's the lie? Are you lying to the judge in your criminal case that you didn't go for work because none of your businesses are operating? You're full of shit. As I believe one of your CT or x-rays said before.
All right. So you're saying that these businesses, these LLCs, there were no tax returns filed individually on behalf of them? Was there or no?
Lizmax, yes. The other ones, the other two you said were Keybacker and Stylete. Is that correct?
Yes.
No, there were no tax returns. Those never got off the ground.
What about Quartet?
Quartet, my parents file on their Schedule C.
Okay. So schedules, your parents are the ones that file on their Schedule C. They have the income quartet flow through to them on their own tax returns. Is that what you're saying?
Yeah, nobody told me LLC.
Okay. Okay. I just have three more questions. So during the paternity action in the state court, you did testify in an affidavit that you had almost $450,000 of cash in checking account. Do you remember stating that under oath in an affidavit in the paternity suit?
That was a misunderstanding with my attorney. So I was going to buy property with the defendant on that, and he knew that I was going to be borrowing the down payment from an investor who he had spoken to using this.
Clayton knew it was borrowing money from an investor. But did you lie to did you lie and say that it was your money to Gingras? Or, oh, it's just a misunderstanding. It's not a lie. And yeah, it's, with things at your fingertips nowadays, like there's no reason that you shouldn't understand certain things when you can look it up and research things on your own. You don't have to be this dumb in this day and age. And she's not this dumb. She's just playing it.
Method called the Morty method, but Clayton admitted under his deposition that he spoke to the guy, and the guy had $450,000 in a money market account, and that's the proof of funds he submitted. It was never mine, and Clayton knew it was never mine.
Okay, so are you talking about Gail Lynn Rich? Is that the investor that you're referring to?
I don't know who that is.
Well, attached to your affidavit,
It was a man named Matt Bentley, and it was his mother-in-law. That could have been what her name was. That definitely could have been her name.
okay, so because you attached a copy of this money market checking account statement to your affidavit claiming, and you admitted in your affidavit that you attached, and I'm quoting your affidavit now, I attached proof of funds to the offers, which included a current bank statement showing I had almost $450,000 in cash in my checking account as shown below. And then there's an excerpt of that money market account. That's your affidavit.
So David was my civil attorney. That was his error, and he will explain that if you have any questions. But that
Well,
was,
I understand that, Ms. Owens, but you're the one who signed it under oath.
I didn't read it carefully enough, and as I said, Clayton deposed to the fact that he's the one who submitted the proof of funds. He got that information. He knew it was never mine.
Okay, so we'll explore that further too. Okay, then what's the
I mean, if you have another question about it, I'm happy to answer it.
Well, my question is, when you made that statement in your affidavit, I attached proof of funds to the offers, which included a current bank statement showing I had almost $450,000 in cash in my checking account. Was that a false statement?
I didn't write that. It's David signed it. I mean, David signed it. David was my attorney. David signed the pleading.
Well, you understand that when you sign an affidavit swearing under penalty of perjury that it's truthful, there's consequence to that. You are testing under oath and subject to penalty of perjury that is a truthful statement. But are you saying that's not truthful now?
The $450,000 was not my error. David will take that. That was not my. He signed that affidavit for me. I didn't sign that. I mean, he knew that wasn't my amount of. He knows that.
He knows that. So David knowingly lied in an affidavit because you're saying he knew that that wasn't my amount. I didn't write that. No, but you signed it. And do not sign your name to anything unless you've read it all the way through. Yeah, it sucks to read all the fine print. But when it comes to court and signing under the penalty of perjury or anything that could get you criminally charged, you better read what you're signing. Contracts, read them. And Gingras is your representation. So things that Gingras says on your behalf are actually coming from you. Johnny Depp got sued for things that his lawyer said or did, and they were attributed to Johnny Depp. Even though Johnny Depp didn't do those things, his lawyer did. But it was in the capacity of Johnny Depp is what they found. So Gingras is doing things in his capacity of representing you. So it is you. It's just bullshit. Gingras will take it. It wasn't me.
You're denying that you signed the affidavit? I have a copy of it in front of me showing your signature.
I believe David had a copy on hand of my signature, and yes,
You authorized him to sign for you, correct?
yeah, I guess that would be what it is.
Well, you're not accusing him of forging your signature, are you?
No.
Okay, so the fact of the matter is you authorized him to sign attesting that this was truthful, but it turns out it's not.
I think it's.
Okay, two more questions. Just, can you tell me the nature of the Owens versus Maricini lawsuit, which is currently on appeal? What's the nature of that suit?
It's a domestic violence restraining order lawsuit.
Okay, and that you had filed against this defendant, Maricini?
Yes.
And did you seek damages, any kind of recovery in that lawsuit?
No.
It was just a restraining order?
Yeah.
Okay, and then, and it says it's on appeal. Who filed an appeal?
I appealed it.
Okay, when did you file the appeal?
I think it was like December 5th. Of 2025. I'm pretty sure.
And how did you get the money to pay for an appeal, to pay for appeal attorney and all the costs associated with an appeal?
I don't have an appellate attorney, and my fees were waived by the court because of my income.
Okay, so you haven't paid any kind of fees in connection with that appeal?
No.
And you are appealing a decision that denied you this restraining order?
It got dismissed because I was in the hospital and I'm on the day of the hearing. So, yeah.
And what's the nature of the Owens versus Gillespie lawsuit that concluded in Maricopa County?
That was a civil case that I filed.
And what was the nature of that suit? What was the claim?
Abortion coercion was the claim.
And were you seeking damages to recover any money in that case?
I was seeking damages, and at one point I asked that they be made to a charity, to a women's charity.
Did you was judgment entered in your favor?
No, nobody ended up getting anything.
Was it how was it resolved? Was it case dismissed, or was there a trial?
And I don't think the court would be able to write a check to the charity or them. They would have to pay you, and you would have to pay the charity. That was a huge thing in the Depp case, that Johnny was making payments to the charity because that's supposedly what Amber wanted. But then she threw a big fit because Johnny was paying them to the charity and not her. And then she received the money and she never gave it to charity. Laura's like, oh, I wanted it donated to a charity. Once again, trying to pull shit out of Amber Heard's book. But it didn't work for Amber Heard. So I don't know why she thinks any of this is going to work for her. And it doesn't matter what Clayton knew. It's what you knew and what you and your attorney wrote. That is it. As far as her deposition, it stinks that we probably won't see it. Because depositions aren't shared unless there's permission to share or something like that. Now, David has leaked parts of depositions, but he has not leaked Laura's depositions, only other people's. But yeah, it's crazy that, like Bruce says, the audacity that she sits there and says that Greg and Clayton and Mike and Dave and Lauren and me and Echoes are all liars. You know, Bruce is a liar. Omar's a liar. Legal Vices and Tug and Megan Fox are all liars, and the obituaries and stuff need to be made. And the stuff that he's said is ridiculous. But they're supposedly the most upstanding citizens in all of the world. Yeah. she acts like she's a victim. She is not a victim. She just lies. All right, let's finish this up.
It was, he filed a counterclaim and it was dismissed for on both sides.
Somebody's got their phone on.
Yeah,
I think it's 602, whatever that number is, I can see. That you can see. Somebody, please mute your phones. Thank you. I'm sorry, Ms. Owens. Can you just...
Guys, if you're watching these hearings, mute yourself automatically. Do not cause disruptions to these hearings. I don't know if it was any of y'all. I'm just saying, if you do, mute yourself. Because somebody not behaving in these proceedings or in court or on Zoom could end up making it to where we don't get to learn anything. And it can mess up things. We have to behave accordingly.
So basically, I just wanted to know how that was resolved. Did it go to trial? Was it dismissed? What happened with that case?
It ended up being dismissed. I think they maybe my side and his side. He filed counterclaims, but neither of us ended up getting anything at the end of the day.
Okay. All right, that's all I have. I very much appreciate you answering my questions, and Mr. Haley, thank you for allowing me to take up so much time to ask these questions. But just to be clear, Ms. Owens, I do intend to have, I will be asking you formally for documents, which will include those bank statements, and I will be asking you to come into my office here in downtown Phoenix for a deposition. In fact, just because since you're on the line and I don't have a phone number for you, I'm not going to ask you to reveal it on this call. But can you please look up my email and send me an email so you and I can talk on the phone to schedule? I want to accommodate your schedule for when you can come in. I don't want to ask you to come in when you're not available.
Yeah, absolutely.
Okay, so it's Jennifer G. Imo. My email address is on the docket sheet.
Okay.
It's just jennifer.a.gimo@usdoj.gov. And if you could reach out to me, we can work on a date to get you in here that's convenient to you. Okay?
It's perfect. Thank you so much. I appreciate that.
Okay, thank you very much.
Thank you, Ms. Chima. Are there any other parties in the meeting who wish to examine this debtor?
Mr. Haley, Marcus Reisinger for Clayton Eckert. I don't have any questions, but I would, with your permission, Ms. Chairman's permission, like to attend the exam.
Absolutely.
Thank you.
All right. Oddly enough, people are still coming into the waiting room, so let me admit everybody, and then I'm going to ask again. All right, probably have a short window here while we have everybody, but are there any other parties in the meeting who wish to examine this debtor?
Mr. Haley, this is Terry Dick. I do have a quick subject.
Yes, sir, go ahead.
Ms. Owens, with respect to Quartet Farms, the Statement of Financial Affairs says that the business is horse sales, leasing, and showing. To your knowledge, does Quartet Farms have any horses currently for lease, sale, or show?
One is he's like for lease, but it's free.
Okay, and where is that animal kept? Is that
In
your parents'
Florida.
business? In Florida?
Yeah.
And where in Florida?
Wellington.
And who owns the property where the horse is?
I'm not sure who owns that. He's at like somebody's boarding barn. I'm not sure who owns it. I can get the information. I'm just not sure off the top of my head who owns it.
Okay. Other than that horse, do you know if Quartet Farms has any other assets?
Like small amounts of like tack and riding apparel, but that's it. And like old horses that are retired.
So it does have other horses?
Yeah, it has horses in like their late 20s.
Okay. And where are those animals kept?
Those are my parents' property.
How many?
There are 7 there.
And do you know, does Quartet Farms have a bank account?
Yes.
Are there any of your bills paid from Quartet's bank account?
No.
And does any money come to you from Quartet Farms?
No.
And when's the last time you've seen the Schedule C for Quartet Farms?
It was last filed in 2022. I believe they got extensions, so I think that would have been the last year.
Okay. When you get Mr. Haley that 23 tax return, if you could get him the last Schedule C for Quartet Farms.
Yeah, no problem.
All right, that's all I have. Thank you, Mr. Haley.
Okay, thank you.
One thing, I just want to, really quick, why don't we just put it on the record? Ms. Owens, will you just consent to Mr. Haley and Mr. Dake sharing with me all documents that you provide to them?
Oh, yeah, absolutely.
Okay, because then this makes it easier, then I don't have to ask you directly.
Yeah, anything, yeah.
We'll get those over to you.
Thank you.
All right. Okay, again, people are still coming in, but while I have a short window here, I'm going to ask one final time. Are there any parties in the meeting who wish to examine this debtor?
That's okay, Tiff.
All right, now
I'm okay
I understand.
with
I'll give an extra beat because I started muting people, but you're going to have to unmute if you want to talk. All right. I'm going to say that for the record, there are no additional people who want to examine this debtor in this case. I've received and verified debtor's social security information and ID. The information matches my records. Ms. Owens, the ID and social security card copy that I saw from you, were those true copies of your original documents?
Yes.
All right, you are free to go then. This meeting is concluded. Thank you for your time.
Thank you.
Bye-bye.
Okay, so that is the meeting of creditors and all that jazz. And so tomorrow, I guess I will go over the stuff, that Gingras's thing that he is possibly going to file in the Rob case, if allowed or is not. I'm going to go over it for the simple fact that I have some opinions about the shit he says in there. Because I'm going to treat it like it's just a blog post right now, because that's how it's written. And so tomorrow at some point, I will be doing that. Oh, no, need to mute that. So we'll be doing that. Let's see if there is somebody that I can redirect you to as we end. Okay, I guess I'm gonna send you over to Shizzy Wiznut. That's the only one that I see that's currently live right now. But he probably doesn't know who I am, but I'm gonna send you over there. And that is going to be it for us tonight. So, yes, you can use the little chickadee. It's not a duck, it's a chick. It makes me mad that there's not an actual duck. Or you can use the mallard, but the chick or the mallard is fine to use. And tell him Loud Little Ducky sent you. But we'll continue to see what goes on in this case and what fuckery these cases will bring. But I will see you tomorrow. Bye-bye.